Let's continue our reading session with regards to Rule 6, kinds of pleadings for civil procedure. We'll do the sections first. We'll read the sections first, and then we'll do the illustration on the next video. I believe the kinds of pleadings really is the heart of civil procedure, since this is the pleadings is basically the answer and the reply coming from each of the parties. So let's read section 1. Pleadings. What's the definitions of pleadings? You have to take note there's no amendment coming from the original 1980 civil procedure. So this was adopted for the 2019 uh, civil procedure. Pleadings are the written statements of the respective claims and defenses uh, of the parties submitted to the court for appropriate judgment. Also based on the 1997 rules of court. Sorry about that. It's not 1980, it's 1997. Section 2, what are the pleadings allowed? The claims of the party are asserted in a complaint, counterclaim, cross-claim, third or fourth party complaint, or a complaint in intervention. The defenses of the party are alleged in the answer to the pleading asserting claim against him or her. An answer may be responded to by a reply only if the defending party attaches an actionable document to the answer. Section 3. Complaint. The complaint is the pleading alleging the plaintiff's or claiming parties' cause of action or causes of action. The names and residences of the plaintiff and the defendant must be stated in the complaint. Section 4, answer. No amendments again. So an answer is a pleading in which a defending party sets forth his or her defenses. Also based on the 1997 rules of court. Section 5, defenses. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material, fact or facts, alleged in the pleading of the claimant, essential to the cause or causes of action. B, an affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegation in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud, statute of limitation, release, payment, illegality of statute of frauds, estoppel, former recovery, discharge in bankruptcy, and other matters by which of confession and avoidance. Affirmative defenses may also include grounds for dismissal of a complaint, specifically that the courts has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by prior judgment. Section 6, counterclaim. No amendments again on the 1997 rules of court. So a counterclaim is any claim which a defending party may have against an opposing party. Section 7, compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with a transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for its adjudication. the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and to the nature thereof, except that in an original action before the original trial court, the counterclaim may be considered compulsory. Regardless of the amount, a compulsory counterclaim not raised in the same action is barred unless otherwise allowed by these rules. Section 8. Cross-claim. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter of either of the original action or of a counterclaim therein. Such cross-claim may cover all or parts of the original claim. Section 9. Counter counterclaims and counter cross claims. A cross claim is any claim by one party against a co-party arising out of the transaction or occurrence that is in the subject matter either of the original action of the counterclaim therein. Such cross-claim may cover all or part of the original claim. Reply. Section 10. All new matters alleged in the answer are deemed controverted if the plaintiff wishes to interpose any claims arising from the new matters so alleged. Such claims shall be set forth in the amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. The reply is a pleading, the office of the function of which is to deny or alleged facts in denial or avoidance of new matters alleged in or relating to said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on the actionable document. Section 11. Third, fourth party complaint. A third or fourth party complaint is a claim that his defending party may have, with leave of court, file against a person not a party to the action, called the third or fourth, etc. party defendant for the contribution, indemnity, subjugation, or any relief in respect of the opponent's claim. The third, fourth party complaint shall be denied admission, and the court shall require the defendant to institute a separate action, where the third or fourth party defendant cannot be located within 30 calendar days from the grant of such leave. Matters extraneous to the issue in the principal case are raised, or the effect would be to introduce new and separate controversy into the action. Section 12. Bringing new parties. When the presence of a when the presence of parties other than those to the original action is required for the granting of complete relief in the determination of counterclaim or cross-claim, the court shall order them to be brought in the defendants if jurisdiction over them are obtained. Section 13. Answer to third, fourth party complaint. A third, fourth party defendant may allege in his or her answer his or her defenses, counterclaims, cross-claims, including such defenses that third party plaintiff may have against the original plaintiff. claim. In proper cases, he or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third party plaintiff. So that ends our pleadings. So next video we'll do the notes with regards to Rule 6 on the kinds of pleadings.